Hello, everyone, and welcome. Thank you for joining Foley & Lardner and Grant Thornton for today's program titled Licensing Agreements, Maximizing Value While Mitigating Risk. Before we get started on today's presentation, I would like to go over a few housekeeping items. If you have any questions about any of today's topics, we invite you to type them into the Q&A widget on the left-hand side of your screen at any time. Questions will be answered throughout the program, time permitting. If you experience any technical difficulties with the webinar platform, please refresh your browser or see the webcast help guide on the bottom of your screen, which is designated with the question mark icon. The recorded version of this presentation will be available on Foley.com in the next few days, and you can find a copy of the slides in the resource list widget on the right-hand side of your screen. For attendees seeking CLE credit, a CLE code will be announced during the presentation. Please enter the CLE code in the polling slide that will appear on your screen. Attendees seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to answering the polling question. A copy of this form is available in the resource list widget on the bottom right-hand side of your screen. Please email your completed form to jdmills@foley.com immediately following the program. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webinar via email. And as a final note, there is a short survey located on the right side of your screen. We would greatly appreciate your feedback on today's webinar. And now I will turn it over to Mike Lockerbie to begin today's program.
Thank you. As many of you know, I'm Mike Lockerbie, one of the co-chairs of Foley's National Distribution and Franchise Practice Group. And many of you also know that if 2021 were a normal year, by now we would have presented Foley's 30th Annual Law of Product Distribution and Franchise Seminar. Instead, right now I'm doing a webinar from my kitchen. The good news, though, is that we do plan to be back in the office soon, and we do plan to offer the annual seminar live and in person, September 15 in our Chicago office, September 29 in our Milwaukee office, and October 20 in our Dallas office. We're also, in the interim, while we have this webinar, privileged to have with us today Brian Moser, who's a partner at Grant Thornton in the Forensic Advisory Services practice. And Brian actually heads Grant Thornton's Forensic Advisory Services practice in the DC area, including across Virginia and Maryland, although he also shows up in a lot of other places. He has more than 25 years of experience assisting clients involved in litigation and government investigations. He began his career as an industry analyst for the U.S. Bureau of Labor Statistics, and also before joining Grant Thornton, spent nearly 15 years with PricewaterhouseCoopers, one of the many names it's been known by over the years. I'm going to turn the floor over to Brian in a minute, and before I do so, I would just say that Brian and I both are very much involved in litigation, and so our approach to license agreements is sort of like that of a marriage counselor who's also a divorce lawyer. We see the ones that go wrong, and we try to help clients avoid them. So with that, I'll turn the floor over to Brian, and I'll rejoin in a little bit.
Great. Thank you for that introduction, Mike, and thank you to Foley & Lardner, with whom we are very pleased to collaborate again as we have in the past. Let's get into the presentation. The learning objectives for today will describe the legal agreement issues that should be considered when drafting an agreement. We will identify reporting and monitoring mechanisms, describe strategies designed to effectively manage licensing contract compliance. We will develop, or at least participants, the objective will be that they can develop strategies for managing the audit process and also determine risk mitigation strategies applicable to licensing arrangements consistent with what Mike just described about hopefully helping people stay out of trouble with respect to their relations with their business partners. As we go into this, I wanted to start with some initial considerations. These are a bit across the board, so to speak, and that there's not a single theme here, but there were things that I thought were important enough to mention up front. Of course, anytime you're entering into a licensing agreement with a business partner, you need to think about what exactly are the financial arrangements and the payment mechanisms. It seems like an overly simple concept, but I put it out there so that people don't overlook the obvious when they get into the agreements, and that you have thought through what type of an arrangement you're going to have and what's going to work better given the situation. Is it better to have some form of an upfront amount, an annual amount, something based on a unit of production over time, depending on however you define production in the respective sector. But it's something to really think about what is going to be most consistent with the interaction between the parties and how that product or license or concept is used. Consistent with that is to think about what are the data sources that would be forming the basis for any payment mechanism. It sounds like it's very much down in the weeds, and it is to a large extent, but you'll see as we go through the presentation that there are many times when trying to assess whether someone has in fact complied with the agreement is challenging, because nobody really thought about what sources of data will be accessible to help a third party come in and do that analysis. The third bullet on this slide is something that, as I look back across the presentation, I realized I think I personally repeated this probably 3 or 4 times to ensure that an audit provision exists. I'm not going to harp on it a lot now other than to say you want to make sure that you've protected yourself and preserved the ability to assess whether your business partner is in fact complying with the agreement that you've worked so hard to enter into. And so it's just something that just make sure that you're doing that. I assume most of the people on this call, based on what I saw with the attendee list, are well versed in making sure that they do that, but we can't emphasize that enough. And then the final thing that I would mention really goes to the big picture of assessing what is the value of the arrangement that you're entering into. Is this the best situation, the best approach to license this product? We could have a whole separate seminar on valuation of intellectual property or franchising situations and what is the best way to maximize the revenue in those situations. But I say this because anytime you're entering into a licensing agreement, up front you should be thinking about what is the best way to realize value from this right that you have. Is it through selling it? Is it through licensing it in a certain mechanism, transferring it, or what have you? I just encourage everyone to stop and assess that up front. So those are some initial considerations. Let's go into some of the more practical things. And as we go back and forth across the concepts here, I hope you'll see that we're trying to address not only what some of the practical implications are, but also ensuring that you're keeping the big picture concepts in mind, such as we just described, for example, with respect to what is the best way to realize the value of your the rights that you have. We talked a little bit on the last slide already about the payment mechanism. And so entering into the agreement, while you may not be focused on this much to begin with, it is important to start thinking about what will the payment compliance situation be like? What will the interaction be with your business partner? Up front, we strongly encourage people to ensure that they have scoped out the collection and remittance responsibility in a very clear manner. Again, this is something that really gets down to a fairly detailed and practical level, but if that's not defined well up front, you can have some headaches down the road that you could otherwise avoid. I think probably one of the more significant practical and yet very detailed areas is to define the basis for any calculations that are going into the licensing agreement. Sometimes it's a very simple calculation. Other times there are many different business factors that need to come into play because of the nature of the business relationship between the two parties. And so because of that, we can't emphasize enough that the more complex that arrangement is, the more work that needs to go into defining the calculations and the basis for them. The last thing you want to have is situations such as I've been involved in the past, where the parties are disagreeing about exactly how a royalty should be calculated. And too often that happens way down the road after the agreement has already been initiated. And our encouragement is to make sure that there's no miscommunication between the parties. And if you need to really get kind of the key people, whoever kind of is the owner of that from each business partner, to have a discussion and talk through and make sure that there's not a miscommunication. Similarly, thinking about how those payments will be made in the future and what support will be provided in conjunction with those payments. There can be a large variation in understanding of what different parties think is, quote, support or reasonable documentation to provide in conjunction with payments. And so I suggest to spell that out as much as you can and to think about, as we said on the last slide, what would you expect to see? What would be reasonable for someone to provide? Again, all in the interest of clarity and ensuring that you don't run into disagreements in the down the road because people had a different understanding of what should be provided to support the payments. And in case we hadn't said it already, which we had, include the appropriate audit provisions to ensure compliance, and really some specifics about what the expectation is there as well. The right to audit clause or what it means to audit and have access to the books and records can mean a lot of things to a lot of people. Think about, will somebody be on site? What specific documentation will they have access to? We'll get into this a little bit more down the road, but there are some practical considerations there. So let's talk about some common pitfalls. We've already raised some of them, but I thought it was worthwhile to put a half dozen or so on a page. First and foremost, and Mike mentioned that he and I are involved in litigation oftentimes, and I have seen it where licensing agreements that started out as a great business proposition for two parties turned into a bad situation because the parties did not fully understand exactly how the financial terms were constructed and what that meant to each party. And so I can't emphasize enough to ensure that there is a clear understanding. I would also say that it's a common theme in situations where I see disputes where the parties really didn't review the calculations in detail. You had very good businessmen that had some concepts that they thought were good in general about how the companies could benefit from their collaboration, and that did in fact happen in these situations. But at the end of the day, there's a very detailed calculation that directly affects the amount of funds that will be transferred from one party to the other. And so if somebody hasn't looked at those calculations in detail, then you're setting yourself up to potentially have a bad situation. I already talked a little bit about the supporting documentation, but ensuring some transparency there, and I know that there are confidentiality considerations that are always in place as well, trade secrets and the like, but thinking through the best way to have as much transparency as you can is very important. I've also seen situations where a long-term agreement has done very well for the parties involved, but then as things change over time, technology advancements, differences in the way people go to market, differences in the customer segmentation, for example, as all of those things change over time, it can have a significant impact on how business is carried out, which can, in certain situations, actually cause the definitions of the terms in the agreement to become unclear. And so that's something that the parties really need to think about as things change over time and come together. And I would suggest to formalize, in certain instances, definitions, approaches, customer segments, and the like in a way that will avoid issues going down the road. Along the same lines of that, the next to the last bullet, I want to emphasize that looking at how your arrangement, your licensing agreement is going, the sooner you do that, the better. I've seen situations where someone doesn't really think about exercising their right to audit until years down the road because they assume things are going well. They're making money, the other side's making money, and so nobody really thinks about it. However, I will tell you that trying to unwind many years of a flawed calculation is very challenging. As a forensic accountant, that's something that we do a lot, but I will tell you that the costs to unwind something when somebody hasn't looked at it up front can be much larger. And I will tell you that the potential risk of loss of a party by having not had the opportunity to nip it in the bud, so to speak, and really get that financial arrangement on track to start with, that can really be a significant financial hit because sometimes the documentation either won't exist anymore or it's hard to get to, and whether you recoup what you should have is not a certainty. And then the last pitfall I'd mention is really, do you adequately assess what is going to be the cost benefit of monitoring and auditing? So based on what I've described here, it might sound like I'm suggesting that you be heavy-handed, so to speak, in how closely you monitor, how often you exercise the right to audit clause. And that's not necessarily my opinion, but my suggestion is you have to think about it in advance and really think about whether the steps that you're taking are worth it, so to speak. What is the risk? And that's something you have to look at on each individual agreement. And we'll talk about how you might right-size that a little bit more as we go forward. So let's talk about mitigating your risk a little bit more specifically than we have. In my view, the more you express up front that you intend to monitor this agreement closely, the more likely that your business partner will also be paying close attention to it and will be doing things in a way that is exactly in compliance with the agreement. You can't ensure that, but if someone knows you're watching, they're more likely to be dotting the I's and crossing the T's. Have we mentioned exercise the right to audit yet? I think we have. I'm not going to belabor that more, but obviously it mitigates your risk. So there are oftentimes a large amount of ongoing support and service level requirements associated with these agreements, but continue to monitor that and ensure that that happens. It's good hygiene to ensure that you are doing all of the things along the way to make this as successful for everyone as possible. I don't really want to get into this a lot, but there can be risk factors in doing business around the world that can affect the effectiveness of the agreement. Keep that in mind in case that's something that you see creeping in that might cause you to need to have a discussion with your business partner. And along the same lines of that, some of the things at the bottom are really on that same theme of ensuring that there is a code of conduct in place. People are operating the way you would expect. Are there third-party distributor risks that are associated with this? This starts to get a little bit afield from really what we're talking about here today most directly, but just give some thought to those things as they may creep into the situation, especially if you're working with business partners who may have operations or manufacturing or outsourcing around the world. So what are some warning signs? We've talked about some things to try to ensure that you're having a good, productive, profitable relationship with your business partner. What are some warning signs? Some of the warning signs, I think, in a licensing agreement are the same as what you see just in business in general. Late payments. If your business partner always seems to be providing whatever it is, the quarterly royalty payment or what have you, several months late or a quarter late, it's a warning sign. There may be something going on where they really don't have a handle on things, and so they can't figure out exactly what they should be providing to you, or it could be a sign that they are really just trying to stonewall you. But late payments, of course, I would consider to be a red flag. I would also consider looking closely at your results being reported over time. If those results are inconsistent, you need to make sure that you know why. It may be that it's an up and down type of business. Maybe there's a lot of volatility in the sector or with this client or with this particular product. But if not, then be leery if you're seeing inconsistent results being reported to you. Similarly, if the presentation of the information that you're receiving looks different every month or every quarter or whatever the period is, you should be asking why that is. You may need to sit down with your business partner and really kind of revisit some of the things that we said in the beginning about putting in place exactly what the expectation is in terms of the reporting and the ongoing process that you have. The inconsistency in the presentation of information in and of itself is not an issue, but in my experience, it's an indicator that the underlying substance might be inconsistent as well. And you don't want to be in a situation where somebody has been coming up basically with a different method of calculation as they go through this. Of course, anytime that you have pushback from a business partner, that should be a red flag, or if they're not returning your calls. And if you're in a licensing situation where they're supposed to be providing information to you regularly, of course, I would see that as a warning sign. I'm going to pause here because there's a question that's come in that I think is relevant to some of the things we've been speaking about for the last few minutes. It says, with respect to auditing, should the licensor be limited to a one-and-done process for audit periods, for example, or that is, once a period has been audited, it is forever closed and not subject to subsequent review? I think that is a very good question, and I don't think there's a hard and fast rule. In my experience, generally, I think most arrangements are not contemplating that somebody's going to go back and re-audit a prior period. However, if you have a reason to believe that you might have specific concern, I would suggest it's not a bad idea to at least have that discussion and think about that. And there are probably some ways that you could word the language such that if something came to your attention, for example, in a later period that had not been brought to your attention in a previous period, it would seem to me, and I would defer to Mike Lockerbie in writing the agreement, but it would seem to me that you should be able to have some language that would cover you in that regard. It's, I think, hard to give a black and white answer to that because there are so many factors that can go into certain royalty payments or licensing agreements that you may not be able to delve into all of the details surrounding it in every period that you go into or want to invest that much money. And so I could certainly see a situation where you went through the first 2 years and everything seemed fine, and then lo and behold, in the third year, you realize there was a piece of information that you didn't really understand what it meant, for example. And so if something like that comes to your attention, it would seem reasonable to me that you could perhaps structure something to take care of that and give you the chance to go back. Okay, I'm going to ramp it up a little bit here to make sure Mike has plenty of time, but some practice tips. I've already talked about being proactive to avoid misunderstandings. Don't sign it and forget it, basically. You know, you should actively monitor what you have in place. We've talked about situations here where parties potentially can end up in dispute, but we strongly encourage folks to establish and build relationships in a positive manner so you can have the dialogue, so you can build trust. And I think that goes a long way because at the end of the day, we are people working with each other. At the same time, when issues come up, you absolutely need to address them directly, set the stage, so to speak, with respect to how is this business relationship going to go into the future. And Mike's going to talk more about litigation, but certainly you need to think about whether you're heading that direction and always be aware of if there is something in that regard that you need to consider. So when it comes to the monitoring and reporting, we've hit on some of this already, but just want to emphasize that as much as you can define up front regarding the form, frequency, what's going to be in that reporting, the better everyone will be as you go forward. We would suggest that the parties have an expectation that there is supporting documentation that is maintained, and I would suggest that you validate that periodically to ensure that either through the right to audit clause or perhaps some other requests if you have the opportunity to ensure that people that you're working with are, in fact, continuing to maintain the documentation that would form a basis to support what your business relationship says it should. I'm going to skip to the next to the last bullet here. A healthy skepticism. I think you already should have that sense for me based on the comments that I've made so far. But, you know, I would emphasize both parts of that phrase. Have a healthy skepticism. In other words, don't necessarily be out to catch somebody in something all the time unless you think they're really up to something. But at the same point in time, you know, do have that skepticism. And the last thing I would say is to collaborate across your teams. And in my experience, a situation where you have a licensing arrangement can really incorporate business professionals from across the organization as well as a range of outside advisors. So you may have people from production, from operations, from marketing, sales, et cetera, who have important information and have been vested in this agreement, especially if it's something that's significant to the business. And at the same time, you may have outside accountants, legal advisors, et cetera. As you go through the process with your business partner, I would encourage you to rely upon people across that group to the extent that it can really help you have the full perspective that you need in these situations. When it comes to looking at your licensing agreements and considering, for example, whether you exercise a right to audit clause or how closely you monitor in certain situations, we encourage you to take a holistic portfolio approach. If you are an organization that has a number of licensing agreements in place, we would encourage you to really think about where can you invest the time. Choose your battles, so to speak. You probably can't spend as much time or invest as much cost with every licensing agreement as every other, but you can think about it. Where do you have the most contracts? What types of agreements are they? What do you think the costs are associated with a more hands-on, closer monitoring type of situation? And so do that calculus. It's going to be different for every person, but we absolutely suggest evaluating that. So for the audit process itself, which again, we do suggest that you exercise that right to audit clause, but when you do so or before you do so, we really suggest that you think, what is the cost benefit here? There are a number of things to think about with that cost benefit analysis. In certain situations, in fact, most that I have seen, there is some element of a fee recoupment. And if you do find that royalties or fees or whatever it is have been paid to you in an amount less than they should have, so that can go into that cost-benefit analysis. Of course, if it's an extremely large stream of revenue for you, the benefit is going to be larger. But keep in mind that usually, in our experience, when you do exercise the right to audit clause, you usually find something. And I would say it's not that unusual that it's a fairly significant amount, but it is an uncertain amount. And so there's a benefit, but it's not always clear exactly whether it's worth the cost. It just depends. And so what we do suggest is at least some level of an audit in the early years can avoid a lot of misunderstanding down the road. And so we would encourage you to do that. But think about whether or not or how heavy of a hand you need to have on that. It may be that you can undertake some relatively less invasive, for lack of a better word, procedures that can highlight whether there might be a misunderstanding, for example, between the entities. And I've seen that before, where I get involved and realize that the two parties should have had a discussion before I was involved because there's just a clear misunderstanding of the language in the agreement. Now, Mike will probably talk about this a little more. Sometimes that's because the agreement wasn't clear, and we mentioned that early on, but some very relatively high level, less invasive procedures up front can really go a long way oftentimes without breaking the bank. Not that, a royalty audit is typically that expensive anyway, but, there's always some level of a cost benefit And then something to really think about for the audit process, and of course your outside advisors will help you think about this, is how do you get to the completeness and the accuracy of what you're testing? And that completeness question, frankly, is one that is usually a challenge because it starts to become sensitive in terms of what information are you going to have access to look across the organization. But those are things that you really need to think about up front in your audit process, and work with your outside advisor if it's someone you're hiring or whoever it is that's doing it for you internally to give that thought process just due, and even consider thinking about including others across your organization, as we mentioned earlier, to get your best thinking involved with that. So, I am going to skip past this, I think, or at least hit it very briefly. When auditing, think about trends, think about performance indicators. There are a number of analytical routines that you can perform. Again, I already mentioned leveraging folks from across your organization. I think we've already hit on the causes of errors. I haven't hit on the one about intent, but of course, anytime you're into a business relationship with someone else, intent can factor in. And we've already touched on a little bit addressing issues for legal input. And with that, I know enough to know that there are legal considerations, but I also know enough to know that I'm not a lawyer. So right now, I'm going to hand the mic over to one.
Thanks, Brian. Lessons learned in litigation. After doing this for 37 years, ever since I was a toddler, I could spend all day talking about this, but I want to focus on 4 lessons that are particularly of concern in licensing. And I think it goes without saying there are different kinds of licenses. You know, there are licenses to manufacture something using IP, but there also are a lot of licenses to distribute goods and services. And this first issue, I'd be remiss as head of distribution and franchise not to raise it, is the F word. Is your license agreement a franchise? This is something that we could spend all day on. I have spent all day on. I'm going to spend just a minute on it. Another critical issue are some pointers about trademark licensing under the Federal Trademark Statute, the Lanham Act, dispute resolution in terms of where you resolve disputes, whose law governs, should you arbitrate or litigate, and then some finer points, drafting tips, tricks of the trade. Some of these are almost as proprietary as the secret formula for Coca-Cola. I'm going to share some of them today, nonetheless. Inadvertent franchises. I've gotten a lot of pushback over the years from some people who focus on IP exclusively at the idea that something might be a franchise. The trouble is all franchises are trademark licenses, but not all trademark licenses are franchises. And you may wonder, why does it matter? I'm going to briefly address why it does. How can you tell the difference? Can you draft around franchise laws? And should you try to do so? The consequences, if a license is a franchise, is under the FTC rule, you have to provide disclosure analogous to private offering circular stock offerings in approximately a dozen states. You also have to register. And then in every state, there are numerous statutes affecting your rights of termination, non-renewal, amendment, sometimes a substantial change in competitive circumstances. It's kind of a lawyer sandbox, and inventory repurchase upon termination. There's some federal statutes along these lines that apply to particular industries, but especially states have laws that either apply to franchises and dealerships generally, or only in specific industries. And this map shown up here in the upper left-hand corner is something that we offer online that allows you to scroll over the country and hone in on what statutes may apply. And certainly give you access afterwards. Consequences for violating the FTC rules, cease and desist orders, civil penalties. There's no private right of action under the rule itself, but creative plaintiffs' lawyers tend to be very good at turning these violations into civil suits or something else. State statutes provide injunctive relief, damages, costs, and attorney's fees. The federal and state relationship laws do the same thing. So you may ask, what is a franchise? Well, that is not a stupid question. And in fact, back in '93, the ABA antitrust section was having its leadership meeting in Bermuda. That seemed to be the closest venue to New York City where the annual ABA meeting was, and was having dinner with the chair of the Federal Trade Commission who wanted to talk about franchise legislation. 2 hours into dinner, he asked, what is a franchise anyway? And I'm thinking, you know, your agency administers this rule and you don't even know? Well, that I think identifies the problem. Basically, there are three elements. One is the trademark license, or even without a license, simply an association with the trademark. Some kind of assistance or control. And then finally, a franchise fee, direct or indirect. And that fee element is only required for the registration and disclosure laws, not necessarily for the laws that affect your right back end. So then the question is, can you avoid these elements, and should you even try? For one thing, and I'm not saying you shouldn't try, we have a lot of clients who have tried and successful in avoiding the franchise. On the other hand, most of them make waiver or even an attempted waiver violation. And the second element, assistance or control, as a business matter that's necessary for a trademark license and desirable, and as a legal matter, necessary. And the reason is to be found in the federal trademark statute, the Lanham Act. And so we're going to cover several topics, the first of which is just to remind you, although I'm only going to really focus on one, that the Lanham Act really is an all-purpose tool for franchisors, manufacturers, and any owner of a trademark. And if you click on this link, you would see, and it explains the bottle of Windex, a little clip from My Big Fat Greek Wedding, where the father sprays Windex on everything and everybody because it's a cure-all. And the Lanham Act, in a lot of ways, really is that, because it does all these things, allows you to do all these things. But I want to, since we're talking about licensing in the context of distribution, talk about the control that allows you to exercise over dealers, distributors, and franchisees, but also that this applies in manufacturing as well. Under the Lanham Act, you have the right to control quality and uniformity. And in fact, you have an affirmative duty to do so. If you don't do so, I think many, if not most of you know, you may risk abandonment of the trademark. And so, you know, the statute actually identifies someone entitled to use a trademark who's not the owner as someone whose use is controlled. The right to control quality is the key. That's important because distribution, you may see situations, although this arises in manufacturing as well, where someone says, well, you know, I can sell these parts as your parts because they come from the same source, or they're identical. Well, no, that's not true. Something is genuine only if the trademark owner has authorized it to be sold trademark. So they've come from the same place, it may be identical, but it is not a genuine trademark product unless you as the trademark owner say that it is. That's a very important consideration. This also means that if you allow a dealer or distributor or franchisee to hold itself out as being authorized, you need a license under the trademark statute, the Lanham Act. There's actually very good case law for franchisors, manufacturers, a couple which are cited here, which I cite ad nauseum, recognizing that control benefits not only the licensor, but also licensees. in these cases, franchisees and distributors, but also the public. And when states have tried to regulate these relationships, we come back for a manufacturer trying to oppose these kinds of statutes, is to point out how important these license terms are to controlling the quality of trademark and services. Those arguments don't always succeed, but they do often. And this cites the South Dakota case with Victory in North Dakota just a year or two ago, making some similar arguments. We're going to talk about best practices in trademark licensing. But one of the lessons learned in litigation is you may have a not so good license and still prevail, have a great license, not prevail. The first example, this is one of literally dozens of cases I had around the country for Volvo over a 10-year period where Volvo had acquired other manufacturers, including Samsung, rebranded the product. Dealers of the Samsung product wanted the Volvo product. Seventh Circuit agreed with us that the franchise goods were limited to the brand specified in the contract. Although, frankly, contract was not a model of clarity. It said excavators manufactured by Samsung wasn't as limited as it might have been. Contrast was involved in this case for Mitsubishi Caterpillar, but the court found that even though the dealer agreement was non-exclusive, and even though the license was limited to one brand, Mitsubishi, appointing a dealer of the other brand, Caterpillar, nevertheless violated the New Jersey statute. So here's some best practices. You need to limit the scope to specified products identified by specified trademarks. Could not automatically amend the contract to add additional trademarks or products. You ought to reserve the right to discontinue products, prohibit assignment and transfer, prohibit registration of trademarks and domain names by the licensee. Some companies allow the use of the trademark in the DBA or the corporate name. Not sure that that's a good practice. Require de-identification upon termination or non-renewal. Provide for preliminary injunctive relief. There was a question about this next point, acknowledging the license ownership and title, otherwise known as licensee estoppel. Question was whether that kind of clause is enforceable, whether it's a trademark, patent, or trade secret. It should be, but it isn't always, but that's not a reason not to include it. You need the right to review and approve advertising use of the trademark. And then it's a good idea to have brand standards that are external to the license that you as the licensor can change unilaterally. Now, there are some unintended consequences, though, of the controls that a trademark owner is required to exercise over licensees. And those consequences are not limited to the risk of being a, quote, franchise. For one thing, there are plenty of tort suits, some of them successful, where plaintiffs have argued that because the manufacturer controls the dealer, or the franchisor controls the franchisee, there's vicarious liability, and some of those cases have succeeded. The other unintended consequence is whether the licensor and licensee, the manufacturer and its dealers, or the franchisors and the franchisees, should be viewed as a joint employer for purposes of labor law and anti-discrimination law. And the joint employer doctrine, I would say the last several years, has been the top priority of the International Franchise Association. It's been kind of a perfect storm of bad facts in litigation and some plaintiffs' lawyers and union organizers who have friends in high places. And in the litigation, for example, in one case, a judge found he characterized franchising as a modified Ponzi scheme. How did he really feel about it? And held that franchisees were not independent contractors, even though the license agreement said they were. And then a perfect example of why elections have consequences, regardless of how you feel about this. President Obama had appointees who enshrined in enforcement and regulations the idea that many franchisors and their franchisees, many manufacturers and dealers were considered joint owners. The NLRB certainly argued that in court. President Trump reversed that. President Biden reversed President Trump. And the only difference has been really a change in administration. There's been some pushback in some state legislatures. The jury is still out as to whether the joint employer doctrine will stand, but right now it's out there. Dispute resolution. One of the raging debates in licensing is whether you should have an arbitration clause litigate. And my comments are going to be limited to the domestic context, because I would say the considerations are different internationally. Now, for example, many licensors in the U.S. Will automatically either, and that's often my advice too, specify dispute resolution in their home court and have it be in a court. But that doesn't always work so well in the international context. Let's say you get an injunction in your home court in the U.S. against a licensee overseas, preventing patent infringement, trademark infringement, misappropriation of trade secrets, copyright infringement. That's great, but you still have to enforce it. And enforcing it means having a final judgment that you can take to a court where the licensee is located. So it may be the case in an international contract that you want to agree to the licensee's form or have arbitration or some combination thereof. Domestically, one of the main selling points for arbitration is that it's supposedly cost less, supposedly faster. You'll get higher quality decision makers. I think the jury is still out, and their experience has proven those points to be a mixed bag at best. But there's certainly lessons learned if you're going to have an arbitration clause. There's some drawbacks that you have to think about and some advantages. And then there's the special case of class actions, which initially arbitration was supposed to avoid. Speed. There aren't really any published statistics about how fast arbitration is. And these averages are pre-COVID. Last year and a half, you throw all these out the window. But the average in all federal courts was close to a year, not too bad. The true rocket docket, the Eastern District of Virginia, is less than 6 months. The Western District of Wisconsin is not far behind. But not to pick on DC or the Eastern District of California, but there, even pre-pandemic, we were looking at close to 4 years, and that's just unacceptable. So that's one factor. Cost. It is true that arbitration is usually free of protracted and expensive discovery, or at least it's not as involved as in litigation. That may be a blessing or a curse. We'll talk about that. But there are some expenses that you don't have to pay in arbitration. Administrative fees, fees of arbitrators. Also, lawyers seem incapable of not trying to make arbitration the equivalent of litigation. We often spend a lot of time and therefore money arguing about ground rules that would be very clear in litigation. There are no judicial checks and balances. That can be a good thing, but you have a runaway arbitrator, and I've seen some, it's a bad thing. But overall, the rules are less well defined. Discovery, oftentimes third-party discovery is key. It is not impossible, but it's very difficult to get a deposition of a third-party arbitration. Definitely subpoena someone to show up at the hearing, but depending upon what information you want, you often don't want to be seeing complex financial data for the first time at the arbitration hearing. And that's often where the rubber meets the road. It's not unusual, unfortunately, for licensees to have at least 2 sets of books. I mentioned the ground rules, but another drawback of arbitration is in litigation. You have lawyers who appear regularly for the same judges. They're worried about their reputation in court, and I'm frankly less confident that my adversaries will live up to their discovery obligations in arbitration. I have more confidence in litigation. Controlling the quality of the decision makers, you can pick what court you go to, but you generally can't select the judge that you have. That's usually random. There is a jury selection process, but it's more a matter of striking some people, usually for cause, a few without cause. You don't have much information. In arbitration, you can definitely specify who the ADR provider is, and some are better than others, the number of arbitrators. If you want an arbitrator who's truly neutral, or someone who's more of an advocate, and you can require specialized expertise. And I've seen this last point be extremely effective, for example, where you require arbitration before someone with a valuation background in questions of valuation upon termination of license, or someone with experience in franchising distribution in that type of dispute. Costs, I'm not sure that arbitration is always less expensive. The arbitrator is billing by the hour. It's oftentimes not quite as busy as a federal judge. You can try and limit the length of the hearing, either by contract or agreement after the fact. You can also reduce costs by having a single arbitrator as opposed to 3. Sometimes that varies by contract, depending upon the amount of controversy. Preliminary injunctions, since the license is going to involve IP. Before, in the olden days, before the ADR providers provided for the arbitrators to issue an injunction, there's plenty of case law out there that the court can preserve the status quo pending arbitration. I wouldn't bet the farm on that now that many arbitration rules do allow preliminary injunctions. So you need to specify in the agreement where injunctions will be sought. Will that be in court or in arbitration? And if you're having a carve out from the arbitration clause to protect IP, you should be sure that it's not so one-sided as to be unenforceable. I have seen some of that. Finally, with respect to arbitration, one of the original supposed advantages was that there would be no class actions. Well, a series of Supreme Court decisions called that into question. I would say the end result, again, I could spend an hour talking about these cases, that if the arbitration agreement doesn't provide for class action, probably okay, but the better practice is to disclaim class actions altogether. We're going to pause for a minute and take care of the Cle Code, and then I'll wrap up.
Thank you. At this time, I will announce the CLE code. For those seeking CLE credit today, please type the following code into the box on your screen and hit the Submit button. The CLE code is P2VZI. That is P as in Peter, the number 2, V as in Victor, Z as in zebra, and I as in igloo. One more time, that is P as in Peter, the number 2, Z as in Victor, Z as in zebra, and I as in igloo. We will leave the box open briefly. One more time, the code is P2VZI. Thanks, Mike. Back to you.
All right, thank you. We have talked about some drafting tips all along, but just a few more in closing. One, as I mentioned earlier, that if you're subject to a state franchise or dealer statute, if your license is, that means that in most states you can't waive those provisions. That's true, but that doesn't mean that you shouldn't have choice of law clause. For one thing, simply having uniform contract interpretation is a benefit. And even if a contract is subject to the New Jersey Franchise Practices Act or the Arkansas statute, Connecticut, whatever, having uniform contract interpretation is a benefit. Also, even if the state statute applies, the law of the chosen state may actually still govern interpretation of the contract. And finally, and this may come as a surprise, there is actually some authority that specifying the law may override a franchise or dealer statute of the state where the licensee is located. And this, I mentioned, 10 years of Volvo litigation. One of these cases, which was decided in the Western District of North Carolina, went up on appeal to the Fourth Circuit. There was one contract, but two different answers, depending upon where the dealers. And in that particular case, the courts held that the choice of law provision would displace Louisiana Dealer Act, but not the Arkansas Franchise Practices Act. Why the differing results? Because the issue is whether the statute reflects a fundamental public policy. And an anti-waiver provision may help show that it's a fundamental public policy, but it's not dispositive. And what seemed to be more important to the Fourth Circuit, and it cited some Fifth Circuit authority for this proposition, is that not only was there no anti-waiver provision, but there was no legislative finding the statute was particularly important, much less fundamental. In contrast, the Arkansas statute not only had an anti-waiver provision, but had an emergency clause. So with that in mind, I've already done this deal. There's also the issue too, if you have a choice of law clause, let's say you're in New Jersey, just specifying New Jersey law. New Jersey is probably a bad example. Let's pick Wisconsin. Would that make out-of-state dealers or franchisees subject to the Wisconsin Fair Dealership? Generally not. Most courts have held that it won't. There's no such thing as a totally bulletproof choice of law clause, but one that is here on the screen that is similar to what the Fourth Circuit upheld, but it's built upon, avoids, hopefully, the risk of inadvertently applying your home state statute extraterritorially, while also increasing the chances that you may be able to override state law. Similarly, another provision that court in that same case found helped override local law was a provision basically putting the burden on the licensee. If the licensee contends that there's some state law that changes the relationship, makes contract provisions unenforceable, basically speak now or forever hold your peace. And the Fourth Circuit looked favorably on laws that were just on the screen and held that these particular dealers were basically stopped from contesting the contractual choice of provision. So I think we're about 1 minute over. If people have questions, Brian and I are happy to stick around. We're not going anywhere literally, figuratively, maybe before too long. But if anyone has any questions that we haven't addressed, please feel free to enter them. If not, thank you, and see you at our next webinar, and hopefully live and in person September and/or October.